Good evening, ladies and gentlemen, and welcome to Quadrant Chambers. We're delighted that you've all come to discuss with us all about whether there is too much interference or not by the commercial court in international arbitration. The format of this evening is that each speaker will have about 12 minutes-ish. I will then ask the other speakers to comment on what they've heard, and then at the end we will open it out to the floor. And with that, I will hand over to Richard Power.
Thanks, Ruth. It feels sometimes that the relationship between international arbitration and the courts is antagonistic. Some arbitration practitioners view arbitration as a vibrant and constantly developing system, ideally suited to the dynamic world of international trade and commerce, in contrast to the ancient arthritic system of the courts. While litigation has its place, where parties have chosen to remove their disputes from the jurisdiction of the courts have no place to interfere with that dispute, and frankly, they should butt out. That view tends to see the commercial court's relationship with international arbitration as one of unwanted interference. However, with a slight sense of trepidation, I would suggest that international arbitration owes much of what it is now to the support given by the commercial court and its predecessors. At the same time, the courts are enriched by the development and growth of international arbitration. And instead of looking at each other as cutthroat competitors, arbitration practitioners should embrace the relationship with the commercial court and celebrate the role that the court has played and continues to play in supporting the development of international arbitration. History provides a useful lens through which to examine the relationship between the courts and arbitration. Arbitration, I would say, has never existed in a vacuum, completely independent from the courts. As Lord Mustill describes in his article Arbitration, History and Background, commercial arbitration must have existed since the dawn of commerce. At the start, it must have involved some neutral determination and an agreement, tacit or otherwise, to abide by the results backed by some kind of sanction. It must have taken many forms, with mediation no doubt merging into adjudication. The story is now lost forever. At first, the arbitration may often have been indistinguishable from whatever procedure occupied the role of litigation. Now, by medieval times in England, alongside the king's courts, disputes were sometimes submitted by parties to the decision of one or more people who we would now call arbitrators. The tribunal will consist of men, and I use the word advisedly, of good standing, chosen by the parties who would hand down a decision that the parties would abide by. However, those arbitrations were relatively few and far between, perhaps not surprisingly given the parochial and underdeveloped nature of commerce at the time. With their expansion of trade in the Middle Ages, special courts grew up to deal with commercial disputes. This was because the early royal courts were mostly focused on disputes over land and conduct contrary to or detrimental to the king's peace. Contacts incurred abroad and debts owed by or to foreigners were almost wholly unenforceable. Therefore, special tribunals were devised to deal with these commercial disputes. These tribunals often comprised merchants elected to the court, often from overseas. And while most of these tribunals were part of the formal court system, you see some of them up there, the stanary courts, the courts of the boroughs, of the fair and of the staple, some of the tribunals were organs of merchants and traders' guilds. While the latter tribunals were different in nature from the official courts, the distinction is perhaps not as clear as you might like to think, because those guilds were very often established by statute or by royal charter, and therefore were more of the official structure than we might think of nowadays. By the 1600s, though, the expansion of domestic and international trade and its increasing complexity made the prospect of resolving disputes in the royal courts of justice even less attractive. So private arbitration started to flourish. But as Lord Mustill said in his article, there were three near-fatal juridical weaknesses which could have severely hampered the development of arbitration. You see the three up there. The agreement to arbitrate was construed as a revocable mandate. So by revoking an arbitrator's authority, a defendant could prevent the arbitration from taking place, or if it had already started, he could frustrate it. Similarly, a plaintiff could not be held to an arbitration agreement. So the defendant was powerless if the claimant decided to pursue his claim through the courts. And finally, and perhaps most importantly, there was no ready means of enforcing the award. By and large, tribunals' awards previously were complied with due to fear of being fined or expelled from a trading guild, or through the moral opprobrium of acting dishonourably. But over time, the power of the guilds waned, and social stigma wasn't enough. So those weaknesses were addressed in a series of legislation that started out with England's first Arbitration Act in 1698, which formally recognised merchants' rights to refer their disputes to binding private arbitration, and culminated in the Common Law Procedure Act of 1854. The legislation gave efficacy to private arbitration by extending the long-established power of the courts to refer to arbitration rather than having it decided by a jury, any complex issue, to the entire dispute. So if a party brought a claim to the courts to resolve a dispute which he had agreed to refer to arbitration, the court could use this power to refer the whole of that dispute to arbitration and stay the court's proceedings. Consequently, the arbitration was treated as an extension of the court action itself, so that the penal powers of the court could be used to prevent non-compliance. By assimilating voluntary arbitration out of court to an arbitration pursuant to the rule of court, the legislation allowed the parties to carry on the arbitration as if it was entirely of their own making, while having in reserve the sanctions of the court to stay an action brought in breach of an agreement to arbitrate, prevent the defendant from revoking the submission, and to enforce the award through court processes. The Arbitration Act of 1889 amended and consolidated previous practices along the same lines. And in particular, the Act codified the existing practice whereby an arbitrator was entitled to state his award in the form of a special case, meaning he could make findings of fact but ask the court to adjudicate on any point of law arising in the reference. This effectively enshrined the right of appeal on a point of law to the courts. That right, known as the appeal by case stated, was part of English law until 1979. It gave parties at the time confidence in the quality of the award and enabled tribunals composed of businessmen to deal with a reference even where it raised complex legal issues. As we know, from then on there was no looking back. Private arbitration flourished to deal with the needs of trade of the empire's commerce. That was due to the support of the courts. So I would suggest that modern international arbitration in England was intertwined with the support given by the courts from birth. Quite simply, commercial arbitration as we know it would not have developed, or at least not as successfully as it has done, without the support of the English courts. Now that support system is dynamic and adaptable to the needs of the commercial sector which it serves. In one respect, the commercial court's supportive role has expanded over time due to the single most important factor which has encouraged the development of international arbitration since the First World War, the New York Convention. As we know, the New York Convention addressed the problems of enforceability of arbitral agreements and enforcement of awards by involving the courts of ratifying nations, so that it would stay, upon request, any action in a court brought in breach of a valid arbitration agreement, and would recognise and enforce arbitral awards as if they were their own judgments. In the English context, the commercial court fulfills that role, and I think this is an excellent example of how the commercial court supports rather than interferes with international arbitration. However, as arbitration has matured, some aspects of the court's powers have had to be curtailed. The case-stated procedure provided an almost automatic right of appeal, which outgrew its usefulness as tribunals became more sophisticated and more often comprised of experienced lawyers than lay people. This became more of a hindrance to arbitration, so the Arbitration Act 1979 removed the appeal by case stated, And the Arbitration Act 1996 now sets the thresholds for obtaining permission to appeal, which is higher than in the courts. In particular, Section 69(3)(d) requires that before giving permission to appeal, the court is satisfied that despite the agreement to arbitrate, it's just and proper in all the circumstances to allow the court to intervene. So I would suggest, ladies and gentlemen, that where we've got to in 2017 is a position where the commercial court provides support, not interference, with international arbitration. But does that support go too far? I believe the balance is right. The power of courts to stay, I won't go into the detail, given that I've only got a couple of minutes, but if we look at just 3 sections, Section 9, I think, is uncontroversial as being obviously necessary to stay court proceedings brought in breach of an arbitral agreement. You could argue that there's no need for a procedure to challenge an award for serious irregularity under Section 68, because institutional bodies like the ICC courts could handle such challenges. But that ignores ad hoc arbitrations and institutions where no such procedure exists. Also, such a right maintains parties' confidence in the arbitral process, and there is a very high threshold for success, possibly too high, some would say. That leaves an appeal on a point of law under Section 69. Critics point out that this is an unacceptable interference with party autonomy, which makes England out of step with other jurisdictions. I would suggest that Section 69 provides fair checks and balances which protect arbitration by ensuring the quality of awards, but also acknowledges the independence of the arbitral process. As Lord Sowell commented, academic objections to interference with party autonomy can be met by an argument that if the parties have agreed to refer their dispute to be decided in accordance with English law and the award is wrong, then unless the courts correct that error, the tribunal has failed to carry out the parties' bargain. If that right of appeal puts England out of step with other arbitration centres, what of it? It could be an arbitral, a USP for London as a seat of arbitration, if parties actually want to include the confidence of having a right of appeal on a point of law to court. What we've focused on so far is the supervisory jurisdiction of the commercial court, which implies that the relationship with arbitration is one way. However, in my view, the relationship with the commercial court and arbitration is mutually beneficial, which enriches and improves both systems. Now, we know that some people have suggested that too many commercial disputes are being decided in commercial confidential arbitrations, and this is stultifying the English law. And last year, the Lord Chief Justice himself expressed fears of exactly that. He proposed increasing flexibility in allowing appeals and greater use of the procedure in Section 45 of the Arbitration Act to refer to the court by agreement preliminary points of law. I think that enough reported cases by commercial court judges help develop the law, at least beyond the threshold of atrophy. However, the handful of arbitral awards that do go to appeal contribute to that necessary development. The chances are that if the court grants permission to appeal, it considers the points raised as being of general public importance. And a good example of that is the Drylog bulk carriers case, where Mr. Justice Leggett, as he was then, granted permission to appeal, even though arguably it should not have been, because a condition stipulated by Section 39(3)(a), that the determination will substantially affect the rights of one or more of the parties, was arguably not fulfilled. But he allowed the appeal to be heard because he felt that it raised points of general importance for the public. The second point of there is that it's not just the substantive law that benefits. Challenges under Section 67, 68 and 69 appeals clarify and develop the law as it relates to the practice of arbitration in England. And the recent decision in SR Oilfield Services is an example of this, where the decision of the court confirmed that third-party funding costs were recoverable under Section 59 of the Arbitration Act and Article 31 of the ICC rules. And furthermore, I would suggest that the practice of the commercial court is enriched by arbitral practice. I think you're seeing a generation of commercial court judges who have had experience of arbitration as counsel letting that experience affect their case management decisions, either consciously or subconsciously. And I had a case last year where the presiding judge said that he had had an experience in an arbitration of the arbitrator suggesting that the experts should have their meeting to narrow issues before, not after service of their reports. And he made that order in his order for directions. And finally, on the other hand, I've seen practices common in the commercial courts start to be used in international arbitration. For example, the tactical use of cold bank offers and making proactive attempts to settle via offers of mediation, which are very familiar to those practicing in the commercial court. So in conclusion, ladies and gentlemen, I'd say that historically the commercial court's support has enabled international arbitration to thrive. That continues to this day and develops a mutually beneficial and adaptive system of support which enriches both litigation and arbitration and helps preserve London's position as a centre of international dispute resolution. I wouldn't bet against that relationship changing again over time, perhaps with the right of appeal being lost. And with that, and with the looks from Ruth, I shall take off my rose-tinted spectacles and don my tin hat. Thank you very much.
Thank you very much, Richard. Thank you, Richard. I'd like to pick up on the points you made about Section 69, because I think that tends to be the most controversial. And the question I'd ask both Guy and Sophie is, one, whether you think it's just a matter of party autonomy and choice as to whether there ought to be a right of appeal for points of law, and secondly, whether it really is a party's responsibility to help develop common law in this country, whether that's substantive common law or common law about arbitration itself. I don't know who wants to go first.
In my view, the balance is about right, because parties and institutional rules frequently do, for example, the ICC, exclude the application of Section 69. From my own personal point of view, I don't really think that the parties are somehow impliedly obliged to help develop the common law by the prospect of an appeal from an arbitration if they don't want it. And they can, of course, exclude the application of Section 69. So I think the balance in regards to that particular section is about where it should be.
Sophie.
Well, and the fact that parties can opt out or opt in, as the case may be, and then choose to utilise the facility of a court review on questions of law is now, it's notorious, and it has continued to be used. So I think it's telling us also something about consumer preferences in that area. Now, quite whether it needs to be an appeal that goes through multiple levels and whether it needs to be one that involves full rehearings as opposed to maybe following the Swiss model that goes more just on the papers in a one-stop appeal, that's something I think to be considered. And
in your experience, do you think parties really have chosen it, or do you sometimes get clients who they know that they've chosen ICC or LCI rules, for example, but they haven't really addressed their mind to whether that means, if the answer goes against them, that they've got no right of appeal on a point of law to an English court?
Well, it's difficult to tell, because aggrieved parties always complain that they don't have a right of appeal. I suppose it depends on how sophisticated the contract is and the client.
And whether it's been truly individually negotiated and so on. But certainly if you talk to most business people about what it is that they prize in a dispute resolution setting, then it's getting a decision quickly and getting a decision that has finality.
Well, thank you. And Sophie, now on to yours, please.
Well, thanks, Ruth. Thank you to Quadrant Chambers for the kind invitation to speak at today's event. I'm going to look at the experience of the commercial court in determining challenges to awards under Section 67 to 69. So actually revisiting some of the points that we've just been talking about now. And what we've done is to do a bit of a deep dive into the data, and data going back to the inception of the Act, which indeed strongly suggests that the commercial court supports rather than interferes in international arbitration. So what I'm going to do is talk you through some of these statistics. In that connection, I just want to say a few words of thanks to one of the senior associates in my group, Hannah Roos, who's here today, for so patiently examining a lot of data in order to get to these beautifully synthesized slides. That's also an invitation, by the way, to put any more detailed data-driven questions to her later on and not to me. Ultimately, however, notwithstanding this sort of positive story that emerges from the data, what I'm going to suggest to you is that we would be naive to take comfort in this positive data if we are going to address what are, frankly, increasing negative perceptions of London as a seat for arbitration going forward. Even before the Brexit vote, London was facing very serious commercial pressures from apparently lower cost and more innovative regional centres abroad, Singapore and SEAC being probably first among those. And indeed the loss of some of our arbitration work to courts of the newer states of the newer member states of the EU. And if you talk to business about why that is happening, the answer comes back, well, actually, the service provided was perfectly good enough. It was fit for purpose, and it was certainly a good deal cheaper. And also, since the referendum, our competitors, haven't hesitated to insinuate the demise of London as a leading seat, and otherwise suggest that Brexit creates some uncertainty for the English common law and London-seated arbitrations. And I actually see this regularly and still, even now, often spending, as I do, more time overseas than I do here, and being at the coalface of decision-making within large corporates and indeed with governments or state-owned enterprises. And while it's too soon for us to tell whether any of these particular pressures are going to work against us in the medium term or the long term, what is certainly clear is that it's increasingly perception that is driving decision-making, and not hard facts and not data and not reality. And the perception of these actors that I talk about is that London is expensive, including because of the role of its courts, and that London now suffers from uncertainty. But let me come back to the issue of perception and how we might change that after we've had a little trot through the data. So as you will all know, an application to challenge an award can be brought on 3 grounds: 67 jurisdictions, 68 serious irregularity, 69 a question of law. Important to have in mind when thinking about this data and what it means, that 67 and 68, of course, are mandatory, and as we've just discussed, that 69 is something that can be excluded by agreement of the parties. So with thanks to Hannah, what we've sought to do is actually build out from some of the findings that you may have seen explained by Sir Bernard Eder in the speech that he gave at the IBA in Sydney in October, that was reported at least in Global Arbitration Review. His review focused on applications under the Act during the years 2012 to 16. A prior analysis had taken place of cases between 1997 and 2006. And so what we have done is to bridge that data gap. When I say we, of course, I mean Hannah, by looking at the years 2007 to 2011, and then building in as well what we have so far for 2017. Of course, there are ways in which this data can never be completely accurate. The methodology used in these 3 different exercises is, of course, different. Notwithstanding that, I think it shows some sort of interesting trends. So we see that the commercial court has heard about between 60 and 90% of the applications, depending on which ground you're looking at, so therefore has had an instrumental role in this area. Focusing first on 67 and 68, the first observation perhaps is that the number of applications is very low. Sir Bernard estimated there to be, these days, between 1,000 and 2,000 London-seated awards a year. Now, even if you take the lower estimate of 1,000, that tells you that a Section 67 or 68 application has been made in less than 1% of cases in the last 2 decades, so frankly, vanishingly small number. And certainly very different from the previous trend where really it was a case of court intervention. And appeals are allowed in less than 0.2% of all cases, again, a vanishingly small number. The court has varied, set aside, remitted, or declared the award to be of no effect in fewer 68 cases than 67 cases, and this sort of supports the view that Section 68 both imposes a high threshold and indeed that courts, respect and observe that threshold in practice. The court is particularly alive to attempts to obtain a review of the tribunal's substantive decision in the guise of a procedural challenge, and this is something actually that we see in other leading jurisdictions such as Singapore, and even the presence of fraud is not sufficient unless it's shown, of course, that its absence would have affected the outcome of the arbitration in some significant way. Examining the results further, the court has varied, set aside, remitted or declared the award to be of no effect in fewer cases in the second decade, i.e. in the more recent times than in the first decade of the Act. This may suggest that the court is applying an increasingly high bar, as the new modus of the Act, the new philosophy of the Act became better socialised and practised. A different picture under Section 69, but probably for good reason. Most applications are made under this section. A larger number of awards were varied, remitted or set aside, about 40% in total in the last 2 decades. It sort of somewhat challenges the view that the chances of success are the lowest under Section 69, but the higher success rate may be attributable to the requirement that a party bringing a Section 69 challenge must have obtained the permission of the court to appeal before the appeal can be brought, which sort of weeds out the more hopeless cases. Overall, the Section 69 data is consistent with Section 67 and 68 in that the total number of applications is only just about above 1% of all awards, and the total number of successful appeals is less than 0.5%. Now, of course, with Section 69, the data is not necessarily telling us a negative story in any event. You'll have heard what I had to say already, that I consider that facility is now notorious among most parties, at least, and what you're actually seeing is that parties are buying into that facility and then utilising that facility, and we can hardly criticise the court for then going on to determine those appeals. Overall, the number of applications under the 3 sections has increased by 20 to 50% in the last decade. Now, is that a negative trend? Approximately a 15% increase in Section 67 applications, a 40% increase in Section 68 applications, and a 50% increase in Section 69 applications. What is it telling us? Is it telling us that post-award litigation is on the increase? I mean, that would tend to suggest that the popular view that parties want speedier arbitration and less court intervention isn't actually being practiced. But the other explanation, of course, is that the number of arbitrations with a London seat is exponentially increasing over time. It's always impossible to sort of know what the absolute number is, but we can certainly look at the cases that are lodged with the LCIA that have a London seat to give us some indication of what's going on. So if you look at the first reporting period, about 147 new cases filed, compared with 643 cases in the period 2015 to 16, so a 300% increase over that period. So what do we think? Room for improvement? I mean, it's always interesting, I think, to look at the models deployed by other leading arbitral seats when we start to think about being smug about what we do in our own jurisdiction. Paris is an interesting, provides some interesting comparisons. The second most popular seat, according at least to the Whiten Case Queen Mary survey in 2015, in the Paris Cour d'Appel, the estimated figures over the last decade are considerably lower than in our courts. The overall rate of success is lower too, at below 10%. Lack of extensive data on award challenges in Paris, but using even the data that's available, it tends to suggest that Paris sees a lower number of applications and appears to apply a higher bar. So what then might we do to improve the data further in the commercial court? Well, possibilities are that we think about indemnity costs as the rule rather than the exception, and rather than even a default practice. The courts in Hong Kong are moving very much towards that model. We might also think about fast-tracking the challenge process. So the Swiss example is very interesting. Award challenges go directly to the highest court, often just on paper. It is a review as opposed to a rehearing. Decisions handed down in a very speedy manner, and indeed in a properly foreign arbitration where both parties are non-Swiss, the parties can opt out of any form of court intervention altogether where the seat is in Switzerland. So that's a sort of rather, an outlier, if you will, in the models of the leading seats, but something interesting to consider at least. So I just want to come back briefly at the end of my address to this question of perception, which in my experience is becoming an increasingly important and I'm afraid negative message that we need to kind of engage with. What factors are playing into that, and what can we do to try and reverse or improve that perception? Well, certainly cost sensitivity is one of those things. I really don't think we can afford to be suggesting on the world stage that commercial actors should be funding the development of the common law. I know much has been said on that issue already. Much has been retracted, in fact, on that issue already. My point is simply that we do need to be mindful of the perception that London has out in the world. The second factor that I consider to be important is one of consistency. So we do have data on our side, certainly so far as challenges to arbitral awards are concerned, but we have to do what we do well and do it in every case. And I think one area where we see something of a divergence in approach is in the enforcement cases. We don't see that similar pattern always in cases in which parties seek to enforce foreign awards. And I would suggest that the area of fraud is one where we see a particular divergence. And the third issue, particularly post the Brexit referendum, is one of certainty. Now is a time where we really cannot afford to create uncertainty so far as London as a seat is concerned. In particular, the courts cannot afford to create uncertainty around things that end users have actually said that they want. So a good example of this, in my mind, is the recent decisions that deal with the relationship between emergency arbitrator rules under the LCIA rules and the role of the court. The customer surveys, the Queen Mary surveys, tell us that more than 90% of users wish to have emergency arbitrator facilities in institutional rules. Yet in that same data group, 50% of them said they would still like to have a free choice whether or not to go to their national court for urgent interim relief rather than use those emergency arbitrator rules. And the recent decision in the Gerald Metals case, I'm afraid, casts some doubt on this and whether you sort of seek to rationalise it by the text of Section 44 or not. The point is it creates a perception that there is an ambiguous and uncertain relationship between the emergency arbitrator rules and the LCIA rules and the practice of the court. So these and other developments could do a great deal, in my mind, to change perceptions and misconceptions of London and its role as a seat going forward. We should be welcoming and encouraging debate on these and other reforms. I think seizing this moment in particular to consider whether a culture of more continuous improvements in the system of arbitration is probably timely. Anyway, perhaps some of you will do so this evening when we have our further discussion. Anyway, thank you for listening.
Thank you, Sophie. So, some questions for Guy and Richard. Again, a two-parter. Do you think a streamlined approach that Sophie's discussed from the Swiss model would be a good idea here? And also just touching on Section 44 of the Arbitration Act, it's now been around for 20 odd years. Do you think it is as it should be, or whether it needs amending?
Streamlined, definitely, and generally. In my own experience, one of the biggest problems with arbitration is the time it takes arbitrators to issue their awards. And this applies, again, in my experience, even where particular bodies have time limits. They tend not to adhere to them or to grant themselves extensions, and sometimes numerous extensions. And I think there might be a case for court intervention to prompt arbitrators to get on with it. Because as Sophie said, most commercial parties want both cost-effective but also swift resolution. Yes, as regards Section 44, I do think there's scope for an update, really to make sure that the powers of arbitrators dovetail properly with the powers of the court, and that there aren't unnecessary and perhaps slightly anachronistic hoops to jump through when seeking relief under Section 44.
Thank you. Richard?
I think if you're talking about a streamlined procedure for appeal to the courts, I think you could be in danger of is the point that there is an objection to the courts being involved at all and increasing costs. And I'm not too sure that streamlining the appeal procedure itself would necessarily address that. I agree with Guy's point about the courts putting pressure on arbitral institutions to hurry up their awards. How that would work in practice, I'm not too sure. But I like it as a theory. I think Section 44 and as Sophie said, the interaction with the supports, pre-hearing support that the court gives is definitely an area where uncertainty needs to be addressed because at the moment I don't think it's satisfactory, and certainly my experience from speaking with clients is they don't like that uncertainty.
We may come back to the floor with the idea of the courts imposing time limits on arbitration tribunals to produce their awards, but let's now go to Guy, and then we can open it up to the floor afterwards.
I'm going to look at the other end of the process, enforcement. And really what I'm going to be looking at is not just the process of registering an award as a judgment, which is straightforward and probably known to all, but the question of whether the machinery available thereafter is fit for purpose. And you'll be relieved to know Procrustean was not sourced from my vocabulary. So the two main options, depending on whether you're dealing with, as everyone knows, a New York Convention award or another award, are sections 66 or 100 to 103 of the Act. And pretty much, it's, with certain very limited exceptions, pretty straightforward, without more, to enter judgment in the terms of an award. It's an ex parte application. And the grounds on which an aggrieved award debtor can try and set aside that order are extremely limited, even at common law, before we move on to the New York Convention. And this, I think, is of particular importance in this jurisdiction because one of the assets likely to be here are funds due under letters of credit. London is one of the two main financial centres out of which letters of credit are issued, although there are increasingly other fora in which that happens. And that really is likely to be a target for an international award creditor anywhere in the world to try and intercept. And what the two main mechanisms for trying to intercept such funds would be are third-party debt orders, or garnishee orders as they were once known, and an order for a receiver to be appointed by way of equitable execution. It's an ancient jurisdiction, but it does have a number of practical benefits. And I've listed three there. The first is provision of information. A receiver is an officer of the court, so he can ask the third-party debtor, the issuing bank under a letter of credit or a big issuing bank, what debts may be due or may be accruing due. The second is the situs of the debt. A debt is an intangible property. Like everything else, it has to have a situs. And a receiver can be appointed, at least since the decision in Masri, over foreign property. Whereas since the decision in Eram, a third-party debt order can only, with one possible very narrow exception, be ordered over domestically cited property. The third real advantage, in my view, is that a receiver can take in a debt which hasn't yet fallen due, where there are conditions precedent to the accruing of the debt. A third-party debt order is only available where a debt is either, in the terms of the CPR, due or accruing due. If you take a letter of credit as a good example, what happens before the beneficiary has presented the necessary documents to either the negotiating bank or to the issuing bank. Arguably, there is no debt due or accruing due. Nevertheless, a receiver could be appointed. As an officer of the court, at least in theory, he could require the relevant documents to be delivered to him, and he could make the presentation. Now, what usually happens in the commercial court when you apply, as many of you may have done, for third-party debt orders or receivership orders, is that stage one is a fairly mechanical ex parte procedure. Interim third-party debt orders are issued, along with interim receivership orders, and they act effectively as injunctions. These are then served, and the award debtor, or the judgment debtor, if the award has been entered or registered as a judgment, comes back, and there is a contested inter partes hearing. It's a flexible procedure. There's often witness evidence and expert evidence, particularly if there are disputes about foreign law or indeed arguments about state immunity. And I then turn, as Ruth said, to talk about one of my own cases, my favourite part, the Taurus and the Somo case. And this, I think, may have ramifications in the future because it is a case in which funds were successfully intercepted under letters of credit, where at least some had treated letters of credit as being some sort of special immune property, almost in their own bubble and free from execution, on the basis that injunctive relief was not available to intercept such funds. Taurus was a Swiss commodity trading company. It obtained an international award against Somo, the state marketing organization of the Ministry of Oil in Iraq. The seat of the arbitration was Iraq. The arbitration, although held in London, had nothing otherwise at all to do with this jurisdiction. And Somo itself said it had no connection whatsoever with England. Despite participating in the award, Somo failed to honour it or any part of it. So Taurus applied for both interim third-party debt orders and the appointment of a receiver by way of equitable execution over letters of credit. The issuing bank was Crédit Agricole London branch, which had issued unconfirmed credits. In fact, the credits were drafted as if the Central Bank of Iraq were to confirm them, but they never were so confirmed. They were issued at the request of Shell, and the beneficiary under the credits was Somo. These are the two provisions which I can take very briefly from the credits which we tried to attach. The first is absolutely standard. It was a request to the Central Bank of Iraq to advise the credits to Somo after adding the CBI's confirmation, which it did not do. We then had two clauses of the credit, which it was common ground, at least amongst the judges and those who appeared, were unusual clauses. Provided the terms of credit are complied with, the proceeds of the credit will be irrevocably paid into the Fed Reserve Bank in New York with reference to the Iraq oil proceeds account, and the instructions would be followed irrespective of any conflicting instructions contained in subsequent transmissions by the seller, Somo. Then we hereby engage with the beneficiary, which therefore had to be Somo, and the Central Bank of Iraq, that documents drawn under and in compliance with the terms of this credit will be duly honoured upon presentation as specified to credit the Fed Reserve. Our argument was that these conditions contained two separate obligations. A primary obligation in debt owed to the beneficiary Somo, and a collateral obligation which was owed both to Somo and the Central Bank of Iraq to make payment in a certain way, which sounded in damages only, which was to make payment to the Fed Reserve. And it was that argument that Lord Mance thought was Procrustean, metaphysical, and other things. in his dissenting judgment. The issues raised on this appeal were the following, and I'm going to leave aside the state immunity issues in view of time. What was the situs of a debt issued by a bank under an unconfirmed letter of credit? There was, in fact, a 1981 decision of the Court of Appeal on a majority, Lord Denning leading the charge, that the situs of a debt under a letter of credit was where payment was to be made, which, as you've seen in this case, was to be New York. And if that was right, that would have been fatal to the appeal following the Iran case. So my ransom arguments on state immunity is an emanation of the state of Iraq, but I'll leave that to one side. Identification of the creditor under a letters of credit, that might seem like a very strange thing to be in dispute under a modern letter of credit, but by the time we got to the Supreme Court, we had had 3 different answers to that question by the 4 judges who'd heard the case. The principle of honest dealing, which I'll leave to one side, whether the interest of the Central Bank of Iraq, however categorized, of itself was a bar to execution, a central bank type immunity point, and lastly, when a receivership order can be made. And the Supreme Court were as divided on most of the issues as the courts below them. By unanimity, the court held that Crédit Agricole only had one situs. That was important because, of course, the bank had branches in various jurisdictions around the world, but Article 3 of UCP 600 says where a bank has different branches in different countries, each is to be treated as a separate bank. Power Kerber was overruled by unanimity, with the result that the situs of the debt owed by an issuing bank under a letter of credit is where the issuing bank is domiciled, in this case, London. By a bare majority, that the creditor was SOMO and not the Central Bank of Iraq. That's the argument that I've just shown you. By a bare majority again, that the interest of the Central Bank of Iraq under the credits was not a bar to execution, and by a bigger majority of 4-1, that the receivership orders ought to be restored. And the most significant, in my view, point perhaps to have come from this appeal is that, at least if Lord Sumption's analysis is followed in future cases, fourth-party interests, in this case of the Central Bank of Iraq, under letters of credit are not necessarily bars to execution. He held that the essence of a third-party debt order was that it modifies purely personal, as opposed to proprietary obligations, by its overriding effect. And since the interest of the Central Bank of Iraq to be paid in a certain way only subsisted for as long as the debt subsisted, the moment the third-party debt order was made, the obligation owed to the Central Bank of Iraq would also disappear, be discharged. Lord Mance, as you can see, didn't agree. He dissented very strongly. He thought this was completely novel, contrary to principle, and he used other descriptive phrases as well. Lord Clark took a different route to the same conclusion. He held that the collateral promise owed to the central bank was necessarily subject to an implied proviso that funds hadn't been intercepted by judicial intervention. And in fact, the UCP does include a force majeure provision, Article 36, so that analysis might be thought to be to have some force to it, although again it didn't persuade, as you can see, Lord Mance. Where does this leave us going forward in terms of interception of funds under letters of credit? Well, as I think everyone knows, London is one of the main two fora in which this interception is likely to be possible. The Crédit Agricole credits were not entirely standard because there was never any suggestion that the Central Bank of Iraq, as the nominated bank, was ever going to pay out by honour or negotiating the credit in Baghdad. So that raises what the possibility would be for intercepting a more standard unconfirmed credit, where the nominated bank usually will, but is not obliged to honour or to negotiate the credit. In my view, at least if Lord Sumption's view is to prevail, there is scope for attaching these types of credits, because when issued there will be two contingent obligations to pay, one to the nominated bank if it pays out, and one to the beneficiary if it does not. The attached promise would be the one to the beneficiary, and at the moment that the third-party debt order is issued, the obligation to the nominated bank would lapse. So I don't see that there is necessarily a bar to intercepting funds due under standard unconfirmed credits. Confirmed credits raises an additional difficulty, of course, because the confirming bank, unlike the nominated bank, does undertake an obligation itself, independently of the issuing bank, to pay. It is perhaps, although I wouldn't put it higher than that, possible that a receiver, combined with a third-party debt order, might be able to attach funds under such credits by requiring delivery up of the documents to be presented, if they hadn't already been presented, and then presenting those documents not to the confirming bank, but to the issuing bank. The last possibility is whether or not pre-judgment attachment of funds due under letters of credit might be possible. Things like freezing orders and the like. Again, in theory it might be possible, although of course not at the behest of the disappointed buyer, because of the autonomy principle and the exception being only for fraud. Lastly, receivership. Receivership, as I've said, is of particular use because you can, in theory, appoint a receiver over foreign assets. So, the situs of the asset being anywhere in the world, although there were a number of criteria set down for extraterritorial receivership orders by Lord Justice Collins in Masry. And perhaps the most difficult one to satisfy in the ordinary course, particularly if the award has nothing to do with this jurisdiction, is the connection between the person affected by the order and this jurisdiction. Because in many cases there won't be an obvious connection at all. There was, however, a flexible and, in my view, commercial interpretation of this requirement in the judgment of Lord Clark in the majority in the Taurus case. He said it was entirely foreseeable that a party being paid under letters of credit would appreciate that those letters of credit would be issued out of one of two financial centres, London or New York, and that of itself sufficed to create a long-term connection between the judgment debtor, SOMO, and this jurisdiction. And that is why, in the Taurus case, by a majority of 4-1, the receivership order was restored. So where one is looking at property which is not cited in this jurisdiction, there may well be greater scope than there has been to date for the appointment of a receiver. Thank you.
Thank you, Guy. Just a quick question for Sophie and Richard, and then we'll open it up to the floor. I suppose, given where Guy thinks it might be interpreted, do you think it would be good for London if funds could in fact be incepted under letters of credit?
Well, it'd certainly be good for litigation funders and those who trade in sovereign debt and, otherwise involved in that end of things. Listen, I think that whole sort of tale rather reinforces for me why it's so important that with any major dispute, we actually start at the end rather than at the beginning, and certainly where the suggestion is that the fight is going to be particularly complex, possibly involve state assets or some organising of assets through central bank or other, other such structures, that we would spend a considerable amount of time and effort and resource thinking about how we are ever going to get to that position, and if we can't, will somebody else in the world be interested in the award on some other basis?
Thank you, Richard.
I think, is it good for London as an arbitral centre or a dispute resolution centre? Yes, I think it is, for the reasons that Sophie said. Whether it's good for London as a financial centre, and particularly in light of Brexit, I'm not too sure.
Right. Anyone have any thoughts, comments, questions?